In this video, we are going to explain about tort law and the subtopic professional negligence.
You know what tort law is?
Tort law is a branch of civil law that deals with wrongs or injuries caused to individuals due to the actions or negligence of others. In a tort case, the injured party seeks compensation or other remedies for harm caused by the wrongful action of another party.
Well, professional negligence is a professional is expected to perform their duties in accordance with the standard of their profession. If they fail to meet the required level of care, they may held for liable for professional negligence. One example is legal negligence. A professional's duty of care may arise through a contract under a law of tort or by statute. This duty may be owed not only to a client but also a third party in certain circumstances. Before we go any further, what is negligence? Negligence is a failure to exercise the care that a reasonably prudent person would exercise in similar circumstances. So, professional negligence include medical practice, accounting negligence, and legal error.
So, we're going to discuss about medical negligence. The question is, what is medical negligence? Alright, medical negligence is a specific type of negligence in tort law where a healthcare professional fails to provide the standard of care expected within their profession, resulting in harm or injury to the patient. Medical negligence can also occur in any medical setting, including hospitals, clinics, or private practice.
In a claim for medical negligence, the patient argues that the doctor or other healthcare professional breached their duty of care, which leading to an injury or deterioration of their condition.
So today we will examine a landmark Malaysian case, Fu Fiona and Dr. Sufumon, decided by the High Court in 1999.
This case centers on the issue of medical negligence. The plaintiff, which is Fu Fiona, was a patient who alleged that her doctor, Dr. Sufumon, failed to exercise the proper duty of care expected from a medical professional.
The court was asked to determine whether the doctor had breached his duty by not treating the patient according to accepted medical standard and whether this failure caused harm to the patient.
Before we continue, let us understand what breach duty of care that happened in this case. A breach duty of care occurs when the healthcare professional fails to meet the standard of care expected from a reasonable practitioner in the same field. The standard of care is not absolute but is measured according to the practices accepted by a reasonable body of professionals in the field. So we now turn to the Court of Appeal decision in Fu Fiona and Dr. Sufumon delivered in 2001. This case revisits the earlier High Court ruling of 1999 where the doctor had been held liable for medical negligence on appeal. However, the court was asked to reconsider whether the doctor had in fact breached his duty of care. Central to this appeal was the application of the Boland test, the standard used in medical negligence cases to determine whether a doctor's conduct meets the accepted practice of a responsible body of medical professionals.
The Court of Appeal found that the defendant had fulfilled his duty of care and that the plaintiff's evidence was insufficient to prove negligence or to establish a clear connection between the doctor's conduct and the alleged injury.
Accordingly, the court allowed the appeal set aside the High Court decision and entered judgment in favour of the defendant.
Let me explain precisely about duty of care. Duty of care is a healthcare professional such as doctor, nurse and other medical practitioners or a duty of care to the patient. This duty arises from the professional relationship established when a patient seeks medical assistance.
The standard of care required is generally that which a reasonable competent professional in that field would provide.
Dr. Mohandas, is this the patient that named for Fiona?
Yes, doctor.
Dr. Mohandas, this patient needs to do an operation to place the dislocated vertebrae into their original positions. This involved an open reduction whereby the nape of her neck was surgically opened and the dislocated vertebrae moved to their normal positions and secured by bone gating and the insertion of a loop of wire to stabilize the spinal cord. Knife. Scissor.
Dr. Mohandas, a neurosurgeon, found that the wire loop which was placed to correct the dislocation of C4 and C5 vertebrae during the first operation was pressuring the spinal cord, and that was the cause of the total paralysis.
As a result of this, the first respondent performed a second operation on the applicant on the same day whereby he removed the wire loop. But this treatment did not remove the paralysis and the applicant continued to be confined to a wheelchair until his death. In her medical negligence, suit filed against the first and second respondent in January 1987, the applicant succeeded at the High Court, proving that
First, her paralysis was caused by the first operation performed by the first respondent and was not due to the motor car accident. Second, the first respondent was negligent in trying the wire loop to compress the spinal cord and reach it to the paralysis. Third, the first respondent was also negligent in not doing anything immediately after the discovery of the paralysis to remedy it. Lastly, the first respondent was negligent when he performed the second operation in the absence of Dr. Mohandas who pointed out cause of the paralysis.
Okay, we now arrive at the final stage of this landmark case, the Federal Court decision in 2007. At issue whether the volume test traditionally used to assess medical negligence should apply to a duty of doctor in advising a patient about the risk of the treatment. This court holds that the volume test has no relevance to the duty and standard of care of a medical practitioner in providing advice to a patient on the inherent and material risks of proposed treatment. A medical practitioner is duty bound by law to inform a patient who is capable of understanding and appreciating such information of the risks involved. This enables the patient to make an informed choice whether to proceed with the treatment or decline it. On this basis, the Roger and Whittaker test is more appropriate and viable for this millennium than the volume test. In Roger and Whittaker, the court ruled that a patient must be informed of all material risks, not merely those a reasonable doctor might disclose. The patient's perspective on what constitutes a material risk must be also considered. A doctor who fails to inform a patient of significant risk may be found liable for medical negligence. Accordingly, the appeal is allowed. The orders of the High Court on quantum are to be restored.